Hello and welcome to ECtHR Talks. Few legal offices in Europe carry such constitutional standing. In the Republic of Cyprus, the Attorney General ranks third among the permanent officers of the state, behind only the President of the Republic and the President of the House of Representatives. He is in a single office both the state's highest prosecutor and the chief legal advisor to the government. This position is currently held by Judge Savvides. Born in Famagusta in 1959, he was displaced from the city in 1974 and has lived in Limassol ever since. He studied law at the University of Exeter and was called to the bar at Middle Temple in London. He then practiced as the founder and managing partner of his own firm for 35 years. His path to his current post is itself telling. He served as Minister of Justice and Public Order for 1 year before being appointed Attorney General in 2020, stepping out of the government and into one of the independent constitutional offices that stand guard over it. On the 16th of June 2026, I had the pleasure to talk with Attorney General Savvides. Enjoy the interview. Mr. Attorney General, thank you very much for accepting the invitation to contribute to the series ECtHR Talks. It's a great pleasure to have you in this series. And we are recording here in your office in Nicosia. Great honor to be with you.
Thank you very much, Mr. Rajad. It's also a great pleasure for me to host you and to welcome you in Cyprus. And I look forward to the discussion we're about to have, which I'm sure will be helpful to all our European viewers.
Thank you. So maybe just to contextualize a bit, this conversation is taking place at the close of the Cyprus Presidency of the EU. It's taking place 22 years after Cyprus joined the European Union. And it's also taking place at a moment of, let's say, profound geopolitical turbulence. So all these issues will be addressed during this interview. But I would like to start this interview with a basic question, which would be very important for our viewers, who are probably not very familiar with this office of the Attorney General. So, Mr. Savvides, most of our viewers, as I said, are more familiar with the continental judicial system, and where the Attorney General does not exist. So, in a nutshell, what is that you do that no single institution in Poland, in Germany, for example, does?
It is obviously the concept of the Attorney General has its roots from the common law systems. And you will see that both England as well as many Commonwealth countries have retained the position of the Attorney General, although having started as having a dual role, namely being the legal advisor to the state as well as the director of public prosecutions. In some countries, we have seen this being split, like in England, for example, we have the director of public prosecutions who does the criminal side of things. Now, Cyprus, unlike all continental countries, has this concept, and we have still retained the dual role of the Attorney General. It's both a legal advisor to the President, to the Executive, to the ministries, and also the Director of Public Prosecutions. Just to give some examples to our viewers, on the legal advice side, what we normally have to do is we have to answer legal questions and legal opinions that are requested of us from the ministries, from the presidency, and so on. We do the vetting of all legislation, all bills prepared by the government before they're put to the Council of Ministers and then to go to Parliament. We have to vet them that they comply with our constitution or with European law. Yeah. We also do all the vetting of contracts that the state enters with anybody, virtually, from the most simple to the most complicated. Airports, hydrocarbons, relationships with other countries, and so on. All these come through our office. We also represent the state in all civil, criminal, and administrative matters. All such proceedings are brought in the name of the Attorney General. So they are defended by people from my office. We attend business, the committees in the House of Representatives where the bills are being discussed, and we advise on things, on matters of constitutionality and so on. We represent the state in all European and international courts, the European Court of Human Rights, European Court, the General Court, International Court of Justice, International Criminal Court, and so on. So it's a very wide role from the legal advisory side. From the point of the prosecution, the Attorney General is actually the person who decides on whether to commence, to take over, to continue, to discontinue, or to recommence any criminal procedure in Cyprus against any person in Cyprus. The only restriction that the Constitution imposes is that the decision of the Attorney General must be based on the public interest. So the Attorney General has an absolute discretion to decide on the future of any criminal prosecution as long as he acts within the public interest. In addition to all this, ex officio, the Attorney General has a particular role in the Cyprus Bar Association. It's stated by law to be the honorary president of the Cyprus Bar Association, is the chairman of the disciplinary committee of the Cyprus Bar Association, and at the same time is chairman of the legal board, which is the body which deals with the preparation of examinations and the other rules of and conditions for admission into the practice of an advocate. So you see that there is a lot in what the role comprises of.
Mm-hmm. Thank you very much. Indeed, and this is very broad. So I've read, it explains probably what I've read in the rule of law report of the European Commission, that there is a reform which is being discussed at the moment in Cyprus, reform to split your role into two. So Attorney General for legal advice and a new General Public Prosecutor for prosecution. So I've read it was approved by the Council of Ministers in July 2025, that it is now before the Parliament. But I've read also that you publicly expressed constitutional reform reservations about this reform. Where do you stand today, and where these reforms stand today?
It is true that just before the latest presidential elections, the issue of the splitting of the roles of the Attorney General became very active in the public discussions. And the current President of the Republic, together with other candidates, said that they wanted to proceed with the splitting of the roles of the Attorney General. Now, the government declared its intention to proceed with this big constitutional change, and I had the responsibility, notwithstanding my disagreements, which I have made public, as you very rightly pointed out, I had the right to cooperate and prepare I think it's about 40 bills that have been in Parliament for this separation, and we had a big team from our office helping the Ministry of Justice to prepare all those bills to be put before Parliament. So, notwithstanding my reservations, my office helped a lot to prepare the bills, and I even signed the document required for the for the bill to go via the Council of Ministers to go to Parliament, despite my disagreement, although I did add a reservation that I felt that there is a good possibility that this reform is contrary to the Constitution. Before reaching this decision, I felt it was proper not to limit my view on just what I personally thought. So what I did, which is something unique, actually, I don't think it happened before, was that I set up a committee of constitutional experts, which consisted of 7 people, 3 individuals from practice, 2 attorneys from the law office, and 2 judges, ex-judges of the Supreme Court, 1 president and 1 judge, ex-judge of the Supreme Court. And I asked them to give me their opinion on what they thought was the constitutionality of this reform. When they gave their opinions, the opinions were exchanged. Everybody had the chance to answer to the other persons. And in the end, 3 people said that the reform could proceed because it was constitutional, and 4 people said that the reform is unconstitutional and cannot proceed. And I must say that my view also is the same as that of the majority of the 4. Out of transparency, all these opinions are on the side of the law office, and every member of parliament has received copies of all the opinions. Mm-hmm. Now, having sent all this to parliament, we had one discussion in parliament when this matter was discussed. My personal view, which is the view shared by the majority of the experts, is that this particular legislation contravenes or touches fundamental provisions, fundamental articles of the Constitution in such a way that it cannot be changed. Mm-hmm. And also it affects what is called the basic structure of the Constitution. And this is, again, something that is not permitted. Just to explain to our viewers why there is such an issue in Cyprus, which didn't exist in Malta, for example, where they changed their constitution.
Yes.
Cyprus has a constitution which was given to it in 1960 upon receiving our independence. It was a very rigid, a very detailed constitution, a constitution that had to deal with the bicommunal nature of Cyprus, the Greek Cypriots and the Turkish Cypriots, and the distribution of places that each community had in the various organs of the company. In 1964, the Turkish Cypriots withdrew from all organs of the government and courts and legislature, so that effectively, under the strict sense of the Constitution, there could be no functioning of the state, because there could not be the required majority for changing provisions of the Constitution, which required the majority of 2/3 of the Greek Cypriots and the Turkish Cypriots. Mm. The courts could not function because there were no Turkish Cypriot judges and so on. So Cyprus was facing a unique problem, which was resolved by a leading case of the Supreme Court of Cyprus, the case of Ibrahim, where the judges then decided that the country must go on, and it must go on through developing the doctrine of necessity, which enables the country to function with as near as possible deviation of as little as possible deviation to the constitutional provisions, but in such a way that no function will come to a standstill. So in this way, the courts which were formed after 1964, which consisted only of Greek Cypriot judges, since the Turkish Cypriot judges have left, were found to be constitutional, and they continue to perform the functions contained under the provisions of the Constitution, notwithstanding that the Turkish Cypriots were not there. So basically, as a result of this difficulty, is not so much an issue whether we like it or not, whether it's a good thing or a bad thing to have a split. We're not the country where we can say, oh yes, this is how we should do it, let's change the constitution. We have to take into account all these delicate political issues, the bicommunal provisions that are directly or indirectly related to this intended change. And my view was that this cannot proceed without putting the whole structure in danger. And when I say in danger, I mean that unless we have the opportunity for the Supreme Constitutional Court to vet this law and the constitutionality of this new law prior to it being implemented, and the only way to do this would be if the President refers it to the Supreme Constitutional Court for an opinion. If we don't do that, we run the risk of the law being passed, we run the risk of a whole structure of the General Public Prosecutor being set up, staffed with tens of lawyers and prosecutors and so on. And then if the next day the first prosecution is signed by the General Public Prosecutor and the accused raises an issue of constitutionality, if the courts decide that it is unconstitutional, you can understand what a disaster it would be to have to dismantle this situation. So this is where we stand today. There's a new parliament as of 2 weeks ago, hasn't started officially its functions. I expect this issue will come up again. I will express my reservations again. I have a duty to express my reservations, and it is then up to the legislature to decide what they want to do. But I felt that historically, being such an important constitutional change, it was my duty to make my position known and put it in writing and put it on record for the future.
So the same rule of law report of 2025 flags limited progress on establishing effective review of your decisions not to prosecute or to discontinue proceedings. And it seems that, let's say, civil society considers this the most important aspect of this reform. You have argued that judicial review would further burden the courts and that hierarchical review is much more appropriate. Is it still your opinion?
First of all, I must admit that from the reviews we're talking about, from the reforms we're talking about, the review of the decision of the Attorney General is, in my view, much more important and much more substantial than the splitting of the role. Because even if you split the roles, you still have someone who will have this unfettered and uncontrolled power. So I tend to agree with this aspect, and I also tend to agree that it is much easier and less risky, if you like, if we were to concentrate on just this reform rather than the splitting, which has the problem I just explained to you. The rule of law report of 2025 gave us the option to either set up an internal hierarchical review or an external judicial review. And this was stated to be in line with what happens in other European countries, and it flagged out that we're the only country which has neither. So the moment this report came out, and knowing the difficulties we would face if we were to go for a judicial review, we were more than happy to introduce the hierarchical review, the internal review. And in fact, whilst in discussions with the Commission for the round of the rule of law, we actually sent them the draft proposal that we intended to put in place to introduce an internal hierarchical review. That would have the benefit of being a review of the substance and not just a review of the form. And we set up a well-planned and well-drafted procedure whereby the victim who was disagreeing with the decision or not to prosecute or to suspend prosecution would be able to apply through this hierarchical review, and there will be an enlarged body which would deal with the particular disagreement.
Lovely.
Whilst we were in the process of setting this up, the government came with the bills for the judicial review. And in fact, as with the previous reform, we helped, participated in a number of meetings with the Minister of Justice and the Supreme Court, where we discussed how this would be put in place. We took precedence, or guidance from countries like the UK, England, and Ireland mostly, which have introduced this judicial review. The problem we have to see and how to tackle in Cyprus is the issue of not flooding the courts with numerous applications, as you very rightly pointed out. Based on the discussions we had, it looks as though the procedure which is being introduced by the bill of the government is for the hierarchical as well as the judicial control to work simultaneously. So before going to court, the victim has to apply for review internally, and if not happy with the review, then he goes to the Supreme Court. But then again, only for a number of very limited and specific reasons, not going to the substance, because it would be impossible to substitute the discretion of the prosecutorial authority, which has the benefit of analyzing all the evidence, what is admissible, what is not admissible, what is impossible to be accepted in court, and so on. So it was not possible for judges to substitute this role. So there are only 3 grounds for judicial review of the Attorney General's decision. That would of the General Public Prosecutor's decision. Let me clear that the way the government bill is drafted applies to the new General Public Prosecutor, and it is now the review can only be on bias, that the Attorney General has some kind of relationship with it, not disclose, not following the rules that the Prosecutor General has laid down for himself to follow, or that the General Prosecutor failed to comply with an annulling decision on the same issue by the Supreme Court on a previous application. So there are only 3 grounds for going to court. This bill coincides with another bill that was brought forward by a member of parliament, where the difference is that the private member's bill shows that the review will start right away, provides that the review will start right away from the current position of the Attorney General. But instead of going to court, she proposes an independent committee, but to review the decisions of the Attorney General. I'm not happy with setting up an independent committee, which is not a court, because that may create issues of access to justice and so on. So we may end up having this independent committee and then again having to have another provision for judicial review. The last thing I wanted to say on this is that both bills provide for the change of the period of appointment of the Attorney General, instead of being until the age of 68, which is the time that Supreme Court judges retire and the Attorney General under the Constitution is appointed under the same terms as judges of the Supreme Court. They want to change that, and they want to make a fixed 8-year term for the appointment of the Attorney General and the Public Prosecutor, neither of whom will be renewable. So this is another change that is to be discussed. Again, I expect that it will be discussed with the current parliament as soon as they start their operations.
So I would like to continue this conversation by addressing the state of the judicial system in Cyprus, and still based on the rule of law report of the European Commission, which I've studied very closely. The report acknowledges significant progress on anti-corruption, so new asset declaration rules in force, the IAAC staffed up from 5 to 18 people, 26 individuals being prosecuted for corruption. What drove this progress, and is it sustainable?
First of all, let me say I'm very glad you point this yourself rather than myself pointing it, because one of the main criticisms that we receive in Cyprus is that we're not doing enough about corruption. And I'm always glad when the people who actually know, and the people who actually read figures, and the people who actually follow closely what each country does have a lot of good things to say about the way that corruption cases have been handled in Cyprus in the past year or couple of years. Yes, we take corruption very seriously, and we understand that this is something which really erodes society, irradiates society. We have to make sure that we fight it as much as we possibly can. However, it is not an easy task. We have a lot of problems in Cyprus to fight corruption because we are probably the only European country without telephone tapping. We are not allowed to legally record and use in court cases, telephone conversations, even after a court warrant. We have set up the procedure, but the procedure hasn't been implemented. We came very close to doing that with the close of the previous parliament, but unfortunately it wasn't passed. So we're probably the only country that telephone tapping is not being used. You can understand that's the basic way that you can collect evidence to use in court. So this is one of the shortfalls. What we definitely have done in the law office is that we have set up the anti-corruption task force, which is headed by the Attorney General, the Deputy Attorney General, or attorneys from the criminal department of the law office. And members are the police, usually represented by high-level policemen, the FIU, which is the unit, the independent unit that is the director of which is appointed by the Attorney General and deals with mainly money laundering situations. So they are also part of this. And also they have the ability, if needed, to join other law enforcement agencies like the Customs Department, the Tax Department, so that we have a wider approach, if you like, in dealing with deception and crimes of corruption, which in some cases it may be easier to establish tax-related crimes than the substantive crimes. So we have a wider approach in the investigations of corruption. In addition, we have excellent relationships with the independent authority and the equivalent commission for sports corruption. We have had a number of cases coming from both committees that have been sent to the police for investigation, and some have already been prosecuted. In some cases, we had convictions as well. We have regular meetings with the police, especially in cases of high importance. we had the CIP, the investment program, with people that obtained nationalities, and there was a lot of allegations of corruption there, and 26 people have been prosecuted, and many of these cases are pending in court. Cases of violation of sanctions. We have regular meetings with the police, and all important cases we hold the police, they come to our office, and we try to follow up and try to give them legal guidance whenever needed, because again, for the benefit of your viewers, the prosecutor or the Attorney General in Cyprus doesn't have the right to carry out investigations himself, like in many continental jurisdictions. We have the police that does all the criminal investigations, and we guide them when it comes to legally guiding them, but we don't actually do the actual investigations ourselves. And let me say that, allow me to read, just to reiterate and reinforce what you just said, what the latest Rule of Law 2025 wrote about the efforts we make, because I think it's important. A lot of work is being put into investigating high-level corruption cases, and more investigations have been initiated. The Anti-Corruption Task Force that operates under the Attorney General's remit continued to supervise the investigation and prosecution of corruption offences, including high-level cases and organized training on assets recovery. This expertise has been crucial, resulting in an amount of more than 8 million euros of frozen assets obtained in domestic cases in 2024, a marked increase compared to the previous years. So I think that this is a confirmation, if you like, that the rule of law sees what efforts and how successful our efforts have been.
So I understand that progress has been made in the area of anti-corruption. Let's move now to another topic, court efficiency. In the 2025 report, I must say the numbers are striking, and disposition time for administrative cases at second instance reached 5,429 days in 2023. So roughly 15 years, and that's the highest figure in the EU by a very large margin. So concretely, what can the law office do about it?
The short answer to your question is that there is very little the law office can do by itself, because in Cyprus we are very proud that our courts are totally independent. So it is up to the courts themselves to consider what they should do to improve the performance and the backlog of cases. However, in the last few years, we have had major reforms in the judicial system, which involved both the Ministry of Justice. It was a cooperation of the Ministry of Justice, the law office, and of course the courts, which resulted in the setting up of a new Court of Appeal, which will be doing just appeals, and splitting the old Supreme Court into the Supreme Constitutional Court and the Supreme Court, which specialize, Supreme Court will specialize with criminal and civil cases. The Supreme Constitutional Court specializes with administrative matters and constitutional issues. From that day, we have seen a tremendous improvement in the time required for the completion of the second tier, for the appellate jurisdiction in all areas of law. And some figures which have been published out very recently, allow me to read out, because I think the difference is very, very substantial and very, very positive. You mentioned that there is this figure of 429 days in the administrative appellate cases. Well, that number for 2024 has been reduced to 489 days. So it's less than 10%, of the figure that was given for 2023. So you understand that, and this is even before another reform comes into play, which has been passed very recently, which creates a second administrative law appellate court, which will start from the 1st of September. So I believe that numbers will drop completely. Just will drop more when we reach, when that reform comes into play. However, since it's not just administrative cases, let me give you some figures to show the progress made on civil cases. In the year 2022 November until March 2026, we had a 30% increase of civil pending cases, which is a very substantial progress. In addition, the backlog cases, and it's defined what backlog cases is cases pending for more than 2 years, have been reduced from January 25 to January 26 by 19.4%. And the clearance rate of the courts in civil cases in 2024 was about 200%, which means that for every one case coming in, 2 cases were going out. So this, in my view, is a good sign that the courts are in the right direction, and I think that there will be considerable future improvement in the future.
So let's move now to another topic, which I would label as follow Cyprus in the recent case law of the European Court of Human Rights. In July 2025, the European Court of Human Rights found in the NT versus Cyprus case that domestic authorities not only failed to investigate rape allegations, but also used language that, in the words of the Court of Strasbourg, conveyed prejudices and sexist stereotypes. How has the law office responded, and what has changed in prosecutorial practice since that judgment?
First of all, let me say that we have a very high respect for the European Court of Human Rights, and we take very seriously all cases which are decided against Cyprus, which is something that we will discuss later on generally. On this particular case, I will tell you that we acted very promptly in order to comply and be in line with what was decided by the court. First of all, we paid the compensation that was awarded by the court. We immediately contacted the lawyer of the victim with a view to establishing some form of communication whereby to establish what the victim's true intentions are as to whether she wishes to prosecute or not the case again. We have disseminated the judgment to all authorities that need to be informed about this particular case. We have given instructions to the police to do further investigations. We have allocated a wholly new team within the law office to deal with whatever is to be dealt with from now on. In other words, none of the people who are involved in the previous case will be handling whatever will happen from now on, including the contacts with the victim. We have made sure that the police change protocols. We change protocols within the law office. And most importantly, we have embarked on very serious structured training of our lawyers to deal with cases like the present. We had lectures both in Cyprus as well as abroad. We even had the president of Grevio coming to give a lecture to our staff in Cyprus. So we're doing whatever is necessary to comply with this decision.
Thank you. Maybe a broader question on that. Cyprus is among the EU member states where more than 50% of leading judgments from the court of Strasbourg from the past decade remain unimplemented, and the law office is responsible for advising the government on how to comply. So what is the problem here? Is it lack of legislative capacity, of resources, of political will?
As I said earlier on, we take judgments of the European Court of Human Rights very seriously, but obviously complying with the decisions isn't always an easy question. Each case has to be taken and viewed independently, because some cases are very easy to comply with, others are more difficult, especially when they deal with structural issues, and I will come to that in a minute. I'm not saying we have. I think I'm not so sure that we have a problem as a country. I think we are in the middle, somewhere in the middle, in the moderate area of compliance. From some scales I have seen, some reports I have seen, were somewhere in the middle of the EU countries as far as compliance is concerned. This doesn't mean it's good enough. We could do better, and we intend to do better, and we are determined to do better. However, I'm not even sure that the figure you mentioned, that more than half of the cases from last decade are still pending. I haven't been able to verify or even challenge what you're just saying. However, the figures that I was given is that in 2024, we only had 9 cases pending. This year, we have 19 cases because there has been a tremendous increase of caseload at the European Court of Human Rights. So judging by the fact that in 2024, we only had 9 cases pending, out of all these 19 cases, only 4 are under enhanced supervision. I doubt whether half of the cases against Cyprus are still not satisfied. However, I agree that there is an issue there. I agree that there is room for improvement. And I can tell you that our aim is to ensure that we comply as much as possible. I'll come now to give an example of the structural problem that sometimes creates an issue. We have been, cases were decided against Cyprus recently based on the conditions of prisoners in the central prison of Cyprus. You can understand this is a result of overcrowding, which is an issue probably faced in most European countries, and you cannot really solve by easy steps. You really have to create infrastructure. I am pleased to see that our government, this present government, has built a new wing to the central prisons, which came into operation last year, which increased quite substantially the capacity of the central prisons. And very recently, they announced that they will build totally new prisons outside the city, which is where prisons should be, in my view. And this is a step that, once completed, will solve all these problems. So we are taking positive steps towards solving even the most difficult cases against us. I don't think that there is a legislative failure or the approach which leads to non-compliance, because when it comes to legislation, and whenever the European Court of Human Rights talked to us, or rather pointed the fact that we had no remedies under Cyprus law, for example, for delays in court and the infringement of the right to a fair trial and so on. We were asked and we immediately complied in setting up legislation to give compensation to people who are the victim of delays in court.
Mm-hmm.
Thanks, sir.
So thank you. Next group of questions, I would call them Cyprus in the European Union and of course the presidency of the EU. So in 2004, Cyprus joined the EU as a divided island. 22 years later, what has EU membership changed concretely, measurably in the Cypriot legal system and in the daily legal life of Cypriot citizens?
A lot. Actually, like every country that joins the EU, immediately finds itself being invaded, if you like, with millions of legislative provisions that are imported. The same happened with Cyprus. But before I go into that, perhaps I should say that the most important legal change that was the result of Cyprus joining was the fact that in 2006 we amended our constitution by the addition of Article 1A, which provides that the European acquis is superior to any law of the Republic of Cyprus, including the constitution, which after I explain to you about our constitution, you can understand what a drastic step this is.
Sure.
In saying that even the regulations, not just the primary legislation of the EU, the whole of the acquis is superior to any Cypriot legislation. So this was a big change for us. In addition, you can understand that both at the stage prior to joining as well as after joining until today, there have been thousands of legislative bills that have been vetted by this office in order to be converted to Cypriot law directives, converted to Cypriot law, and this has brought up a very big change into our legal system. To be honest, I think that this is a big advantage because I think that for a small country with limited resources like Cyprus, the fact that you have the centers of legislation of Europe with all the experts on the specialized fields, having all the knowledge which is required in order to draft and conceive what needs to be changed in the various fields, I think is a big advantage that we have these technocrats preparing the legislation and bringing it to us already, rather than having to invent and create them ourselves, especially in complicated matters like environmental law, rule of law, corruption, digitalization, AI, all the modern things. I think that's a big advantage. Now, on day-to-day life, another couple of changes perhaps worth mentioning was the introduction, or rather the accession of Cyprus to the EPPO at the time, from its inception, at the time that it was not obligatory for us to do so. Mm-hmm. I mean, the only other main common law country, Ireland, has still not joined EPPO. This shows the intention of Cyprus to share what is European and what is being developed within the European Union. And EPPO is one of them, and we have joined them from day one. This is another important aspect. And if I may take another example of our recent experience, we had a huge problem last year with the vehicle recall system when there were defects in certain parts of vehicles. We had the airbags that were defective, and I think this was a problem all over Europe, but in Cyprus it was a bigger problem. And the fact that we impose European legislation, European regulations, it meant that we had to make sure that the cars that enter Cyprus have the certain standards, that the recalls are taken care of, and that no car can have an extension of its certificate of ability to be used in the roadworthiness unless all the recalls have been taken care of. So on the whole, yes, everything has changed in the legal world. Problem, we always have to remember that we are a common law country, and with Britain leaving the EU, it's fewer of us remaining as common law countries, and sometimes we just have to be careful when we transpose provisions to remember that we retain our common law origin, which is the heritage that we have had for hundreds of years.
We are speaking in the final days of the Cyprus Presidency of the EU, and the rule of law and access to justice were listed as central values across the entire presidency program. As Attorney General, what has been your specific contribution to that agenda?
We begin with a more generalized view of the presidency. We were very, very concerned and worried when we're about to commence the presidency, because when you're a small country with very limited resources, you are always concerned whether you'll be able to meet the standards expected of you by fellow member states. Just to give you an example on the load that this office alone had, we were presiding over 17 committees, either in Cyprus or in various other places in Europe, on different issues. And you can understand, with such a small number of staff, being able to accomplish this role was quite a stress on our resources. I must say that I have received such good reports and such good remarks about participants that I feel obliged to thank all my colleagues for all the hard work they did during this presidency. Rule of law is really the heart of our democracy, and it's the most important single element that all countries have to join forces and work together. And it's a developing matter, new rules, stricter rules from year to year. Yes, it has been a priority of our presidency, and I can tell you that we have done a lot in that particular field. My colleagues in Brussels have participated in 2 discussions, horizontal discussions about the rule of law under the auspices of the Council of Europe, of the Council of the EU, and one in January and one in May, where they had horizontal discussions with colleagues on this very important issue, and exchange of views, exchange of best practices, which is most important to achieve an understanding of where the other stands and how you can improve and how can each get the benefits of where others are better and follow them. Likewise, we had a very high-profile conference in Cyprus about the rule of law, a 2-day conference in May, where we had the pleasure of the President of the European Court attending and speaking, as well as Commissioner McGrath, the Commissioner of Justice of the EU.
So the presidency has pushed hard on gender-based violence and the protection of minors online, which are areas where Cyprus itself has been found wanting by the European Court in Strasbourg. Is there not a certain tension in championing these priorities at EU level while facing criticism at home?
I hear what you're saying, I respect your opinion, but with respect, I think that it's not fair to equate one or two European Court decisions as being effectively equating with the general policy of failure to take certain things seriously. And I can assure you that, notwithstanding the fact that there have been one or two cases against Cyprus on these issues, the efforts we're making in this office, particularly in the prosecution of cases based on gender violence, as well as on abuse of children, are very, very serious. In addition to the continuous education that we offer to our prosecutors, we have successfully prosecuted a great number, a much bigger number than before, on cases of gender-based violence as well as abuse of children, sentences of imprisonment which are much higher than there have been in the past. The instructions all the prosecutors have is whenever they feel that any sentence imposed in these fields is inadequate, to appeal, and we have appealed. And if one reads the cases of the appeal court, you will see that there has been a trend to increase prison sentences. Once the prison sentence is increased, that means that it has to be followed by all courts. So I think that there has been a lot of improvement in that particular area, coupled with education, coupled with the excellent relationships we have as a law office with NGOs that deal with the issues of abuse of women and gender-based violence and abuse of children. So we have an all-round policy. We have specialized staff that deals with these particular cases. We do take into account, and as I explained earlier, we have taken into account the adverse decisions of the European Court of Human Rights. And I think that if one judges the position as it is today, you will say that a lot of improvement has been made and a lot has been done to combat these types of crime.
Thank you. The next topic I must address is Turkey. Turkey remains a candidate country of the European Union, even if negotiations have been frozen for years now. Turkey occupies more than a third of your country's territory and refuses to recognize the Republic of Cyprus. From a purely legal standpoint, how do you characterize that situation today under international law?
Let me, before getting into the legal side, tell you that the invasion and the occupation of our land is an open wound for all us Cypriots. It's even more of an open wound for those of us, like my family, because we were forcibly evicted from our houses in 1974. I come from Famagusta, an area which is now occupied, and we got into our car on one morning with a few clothes and a few personal belongings, expecting that we would be back probably the following day or the day after. And it's now 52 years almost that we have been away from our homes and our territory. So you can understand what it's not the legal side, but it's the personal side that we're all facing. Coming to the legal side, I think Turkey has to understand certain principles that the invasion, the occupation, and the continuing refusal to be constructive in solving the Cyprus problem is against international law, and it has been condemned by numerous resolutions of the United Nations. Cyprus, the Republic of Cyprus, legally is the only recognized entity in the in the world. Is a member of the United Nations, is a full member of the European Union, the Council of Europe, and it's the vehicle that represents Cyprus, and it has to be the vehicle to continue to represent Cyprus after a solution to the Cyprus problem. And when I say Cyprus, I mean the Greek Cypriots and the Turkish Cypriot community, all of us. Unfortunately, not only they invaded, not only they occupied, they created the so-called Turkish Republic of Northern Cyprus, a so-called state which has not been recognized by any country other than Turkey. At the moment, there is an initiative by the Secretary General of the United Nations to get the two sides together and resume negotiations. I hope this will succeed, and I think that our side has every intention to cooperate. I think Turkey must understand that the proposal of solutions which are outside the UN resolutions, like, for example, the insistence on a two-state solution in Cyprus, is something that will not be accepted by anybody, most particularly by the European Union. Turkey wants to come closer and improve its cooperation with the European Union. I think that for this to be possible, they have to comply with international law. They have to comply with the Cyprus-related obligations that they have to recognize the Republic of Cyprus, and hopefully they will get down to the negotiating table based on the principles of the United Nations.
The Law Office has spent decades documenting Turkey's violations before international courts and bodies. Given that neither the ICJ, the European Court of Human Rights in Strasbourg, nor the UN Security Council resolutions have ended the occupation, is international law actually working for Cyprus?
This is a very good question, and of course a very difficult answer. Is there any other choice than pursue international law? When you are a small country, when you're a country that is, you base your arguments on international law, that's the only way to solve your problem. There is no way you can fight, there is no way you have the strength to enforce through a war and get back your land. I think that inevitably we have and we do put forward international law. International law by itself will not solve the problem. But however, the intention is to create and improve international law in various areas so as to use the outcome in a way to promote diplomacy and political pressure for the government. This, unfortunately, is the situation with small countries which cannot really force and obtain what is fair for them through other means. We have been very successful in the leading case of the fourth interstate case against Turkey, which was issued in 2014, where the European Court of Human Rights noted all the flagrant violations that Turkey did in Cyprus of human rights. We're building on that, and we're helping creating arguments for our government to pursue diplomacy and use international law as a means, as a weapon for promoting justice and resolution of the Cyprus problem through political means.
So where do you see the most realistic legal avenue for progress on the Cyprus-Turkey issue? And how important is the EU support in this respect?
I think that the most important starting point is to set up the parameters under which the problem can be solved. And the parameters have been set down by the United Nations resolutions and by all other organizations, including the European Union. It has to be a solution of a bizonal, bicommunal federation with equality between the two sides. And this is really the parameter within which we have to work. Europe has helped a lot, and we're grateful for that. They can help even more, and they can help even more by making it clear to Turkey that the avenue of Turkey achieving its goals, which are to get closer to Europe, and Cyprus has no objection for this to happen, as long as they realize that they have to comply with all their obligations, and particularly the Cyprus-based obligations. Our aim is to reach a fair and lasting solution. And I think that we depend a lot on Europe, European Union, to help us achieve this goal. For this to happen, Turkey must realize that they have to bring their policy within the framework of the decisions of the United Nations.
So let's move from Turkey to the crisis in the Middle East. Cyprus is the easternmost member state of the European Union and the only one actually geographically based in the Middle East region. I think it's important for our viewers to understand that you take the plane from here to Beirut, it takes 20 minutes.
Same to Israel, same to all the neighboring countries.
Exactly. Yes. So the presidency has highlighted Gaza reconstruction, relations with the Gulf and the Levant. What is the specific contribution of the law office and of legal expertise more broadly, to Cyprus' role as a bridge in that region?
Cyprus has always been acting as an honest broker, and especially in cases of crisis, we are trying to use the good relationship we have with most of our neighbors to help bring solutions to various problems, not on the substance of it, but perhaps on peripheral issues that result or are generated by virtue of the geographical position that we're all in. Now, your question relates as to what the law office has done in relation to certain of these issues, and I intend to limit myself to that because I'm not a politician. And the sense is I can tell you certain areas where we have been very active in matters that affect our neighborhood. First of all, we have been advising and participating in meetings with neighboring countries on setting up the delimitation agreements with the with the zone of each country or each neighboring country. Likewise, we have been advising the state on a number of agreements with petrol companies or even with neighboring countries on the exploitation of hydrocarbons together with neighboring countries. We have also been involved in doing drafting of agreements relating to the Amalthea path, which was the path that was created to convey, to pass aid to Gaza. We have also been vetting agreements with EU and other countries in emergency evacuation of European or third country nationals from war zones in the Middle East to their countries. And generally, if I may extend this a bit to the wider issue of Ukraine and Russia, the law office is representing Cyprus, who has joined with 25 other member states the application that Ukraine filed against Russia at the International Court of Justice, and we are representing Cyprus as an agent together along with the other member states, which again is another indication of our value of the European attitudes and policies.
Thank you very much. Last question. Your mandate will end up next year. And if you could achieve one concrete legal or judicial reform in Cyprus before the end of your mandate, what would it be?
I would like to see the implementation of the vision we had when we took our positions here, myself and the Deputy Attorney General, in the reform of this office. We have done a lot to improve and to make this organization more prompt and more specialized to achieve its constitutional role in the best possible way. So the areas I would like to concentrate on would be to continue our efforts to properly staff an office which is now understaffed. I'm pleased to say that very recently I received the approval of the executive for the increase of our legal staff by 32 lawyers, which is about 15%, and we're looking forward for that to be implemented. That will help us achieve another target, which was the creation of sections and subsections in the various fields of activity, given the wide scope of our mandate. And that has the benefit of both follow-up by the hierarchy and at the same time creating more specialized lawyers who will then be more efficient to complete their tasks. So that's the second area we want to concentrate in. The third area is I want to see the further growth of our academy. The academy is something that we have created during our period, the last 3 or 4 years, and I'm very pleased to see that it's doing a fantastic job, both to educate and provide structured education to our staff, but at the same time to help government departments to understand certain legal issues so as to be able to better do their jobs. And we have had numerous programs which were addressed to outside agencies, departments, and so on. So in this respect, I feel that we're giving a lot more to the community, to the government through this educational program. So I want to see that improved. I would like to see the completion of the digitalization of the law office. When we came in, there was absolutely no digital tools. We have introduced both the case management as well as automation systems together with other auxiliary programs, and now we're moving into a direction of where we should be many years ago. We have digitalized our files, so that's an area where I would like to see some more improvement before I leave. I would like to see the building of the offices, which has been one of my dreams, if you like, because currently we're split in 5 different offices in Nicosia, and the plans are that we will be having a new building right behind where we are at the moment. And again, thankfully, last week I heard that the government has decided to put that in priority, so hopefully we will see this processing. And generally, my target would be to leave behind the law office in a better structure and efficiency than I received it 7 years ago. However, and let me finish with this, for me, and I can say this because one of my tasks is that I participate in the team that the president set up to provide him with legal support for the Cyprus problem, for the Cyprus issue. And I have participated in all the previous international conventions or meetings and gatherings that have taken place in the last few years. In that capacity, yes, I do have the dream or the vision to help insofar as I can to contribute to a fair, just, and viable solution to the Cyprus problem. I believe that 52 years is a long time that we have been apart. I believe that there is a lot of future in the United Cyprus. I believe that it is time for those of us who lost their houses to return to their houses and properties. The same applies to the Turkish Cypriots. And I believe that we should all have the vision of reuniting our country. And I hope that this will be achieved through the latest initiative of the Secretary General of the United Nations.
Mr. Savvides, we have reached the end of this interview. Thank you very much. It's been a great privilege to interview you.
Thank you very much. It was a great pleasure for me as well.
Thank you.